Hello, my name is Nathan Dennis, and today I'm here to explain to you how you could potentially get your Second Amendment rights back if you've lost your right to bear arms because you were committed to a hospital involuntarily. So if that's you, then this is the right video for you. Now, kind of saying the same things as I said in the other videos that I made, but this is more of an in-depth analysis of what you can do in your court case and what you can't do. Now, I'm not a lawyer, so please take everything I say with a grain of salt, but this is my interpretation based off of everything that I read and talking to lawyers and reading case law and doing my research on these types of things that, based off of my interpretation of it, this is most likely what you can do and some things that you can't do. So, if I'm wrong about something, I do apologize, but this is my interpretation from how I understand it. But I shouldn't be wrong. So, anyways, so first and foremost, also, as I stated in the other video, if you've watched it, if you're involuntarily committed, generally speaking, there's two types of laws that you have to worry about. There's state law, and then there's federal law. Okay, and generally speaking, state law generally mirrors what federal law says in the wording. So under 18 USC 922 G4, that's the federal statute, it says that if you've ever been adjudicated as mentally defective or if you've been committed to a mental institution, then under that law you are prohibited from having a firearm, basically. And most states follow that same the same language in their state laws too. So generally speaking, you're barred from both state and federal law. And right now, they're currently so there's a way to get your rights back. Now, different states have different rules and different procedures and how they commit you and how you can get your rights back. But at least for the federal government aspect of it, there's a federal ATF Federal Relief Program that was passed in 2007, which is a program that allows you to relieve your federal rights back through state court. So basically, you can file to relieve your state rights, but it also relieves your federal rights simultaneously too if you file in the state court. And currently, only 33 states as of right now qualify for this federal relief, basically. The ATF, they have a certain guideline of what should be met when it comes to whether or not you qualify for the federal relief for the state, basically. And currently, like I said, only 33 qualify, but 17 do not, which means that if you try to relieve your right in those 17 states, then it will only relieve the state disability, but you will not get a chance to relieve your federal rights because the ATF does not recognize the state programs as sufficient enough to qualify for their program. And I'm going to list the names of those states, and those states right now are California, Colorado, Connecticut, Georgia, Maine, Michigan, Minnesota, Montana, New Hampshire, Ohio, Rhode Island, South Dakota, Vermont, Washington, Wyoming, Arkansas, and Mississippi. Now, there might be one or two that might be incorrect or one that might be missing, but based off of the ATF's website that lists all the states that are approved, that it's up to date, so far only 33 are approved. So these states are not included in the approval of the ATF program. So if you live in those 17 states, what you have to do in order to get your rights back is you have to, and it sucks, but before saying anything else, there's a difference between state court and this federal court, okay? State court usually deals with issues regarding state law and stuff within the state. They can sometimes answer federal questions, but generally it's bound within like the state itself. And then there's the federal government, federal court, where they generally argue stuff regarding federal law or the Constitution, basically. So in order to restore your rights, in those 17 states, federally at least, you have to file an injunction with you have to file an injunction in federal court, basically suing ATF, the FBI, and some directors of the federal department. I don't know which one exactly, but you have to sue the federal entities that are barring you from being able to have a gun, basically federally, and you would have to sue them for a remedy under the Second Amendment, that they're violating your Second Amendment rights, basically. And again, I apologize if I'm jumbled up, but I'm thinking from the top of my head now. I'm explaining it, but basically, an injunction is basically it's a court action where a federal court or state court, but court is stopping a certain entity from performing a certain action. Basically, you're saying that you've been caused a harm by that entity, therefore you want them to stop what they're doing. So basically, if you file an injunction, that injunction will stop the FBI from having your name on their NICS database system. Basically, that's the FBI database system that does all of the gun transfers and you being able to purchase a gun, this and that. It's that federal background check, basically. You're forcing them to remove your name off of the database system. That's what an injunction is, and that's the only way you can get your rights back if you live in these 17 states, is by doing that, because there's certain legal requirements and court doctrines and this and that prevent you from doing other things, which is what I'm going to try to explain to you today. It's very convoluted and it might be jumbled up, and I do apologize, but I'm not a lawyer, but I'm reading based off of my research and what I understand so far. So it would have to be in federal court because so I'll try to explain it. Okay, so there's claims that you can make. There's the Second Amendment claim, and then there's Fifth Amendment claim, and then a 14th Amendment claim. Those are claims that people generally would like to make, but there's only really one claim you can really make, and that is the Second Amendment, per se. And I'll explain to you why you can only do the Second Amendment and not the Fifth or 14th Amendment. Even though you can put it in your petition, it will most likely be rejected by the court because of certain court doctrines that exist. So I'm going to go in and explain it to you. So I'm going to read off some things that I wrote down, and hopefully it's not too convoluted. And I'm going to read some of the things that, I'm getting some of the information from a law website, and there's legal analyses of lawyers that look into the law and this and that, about on certain cases regarding this particular issue, and then just reading state law and federal law and case law pertaining to this. So first I'm going to start off by talking about the 14th Amendment, basically, and there's different reasons, so there's two different types of claims under the 14th Amendment. It's kind of the same with the Fifth Amendment. So there's procedural due process under the 14th Amendment. Then there's substantive due process under the 14th Amendment, and then there's also an equal protection clause under the 14th Amendment. Now I'm going to read to you why under the 14th Amendment you wouldn't be able to make a claim, and again, this is my interpretation. Okay, so give me a second. Like I said, if I stop and start, I apologize. I'm pulling up stuff and I'm reading it. This is a live reaction. So okay. So again, I apologize if I'm jumbled up. So before I say anything else, let's see. An equal, like this is what I'm reading from this site. An equal protection argument is likely to fail. That claim would be dismissed because basically a court could still find that 922G4 is constitutional post-Bruin, as the Third Circuit likely would have. Therefore, analyzing alternative arguments to 922G4 compliance could make it important. I messed up on that a little bit, but if you've seen any court doctrines or any court cases recently, if you know anything about Heller or Bruin, those are court cases that affirm that individual citizens have Second Amendment rights, and that, generally speaking, under the language of Heller, only like people that are felons and people that are mentally ill are excluded from the Second Amendment, from the language of the Second Amendment, and it's presumptively lawful, that aspect of it, and that means that it's constitutional as it's applied to that statute, or I'm sorry, the language of that statute of the Second Amendment. There's no protection for people that are barred from having a gun because of felony conviction or they're deemed to be mentally ill. Here, you couldn't make an equal protection claim because so the federal relief program, it is called a 40195. Basically, I get some federal number or code or whatever, and basically it says here that so as I said, the 17 states that that prohibit, that don't allow you to relieve your federal rights because they don't qualify for the program under the ATF's rules, and that you would fail to make a claim because I am messing up so bad, and I apologize. So you wouldn't be able to make an equal protection claim, and it would not be successful due to the plaintiff's inability to identify a similarly situated party that the named defendant is treated differently, and because the result of the federal court upholding on equal protection claims against 40915 would likely cut against Supreme Court precedent. An analog scheme found in immigrant benefits and why an equal protection claim has merit but is likely to fail. The current 40915 scheme is a unique one with few parallel offered in any law, although one such parallel can be seen through the cases involving benefits offered to immigrants through the state and federal governments. Like 40915, immigration cases present examples of the federal government creating systems that allow for the unequal treatment of people from state to state. However, because the plaintiffs in those cases failed to point a similarly situated individual who were treated differently by the state, there was no discrimination, and there can be no equal protection violation without discrimination. Further, courts noted that claims against the federal government would also likely fail. The conclusions of these courts can be extrapolated to 922G4 cases to reject potential equal protection claims against 922G4. An equal protection argument can be broken into 3 steps. First, the plaintiff must identify a similarly situated party that the defending entity has alleged treated differently. At this step, 922G4 plaintiff would have to claim unequal treatment in comparison to the average American, or unequal treatment in comparison to those also in 922G4 class. A claim under the former argument would be an attack on 922G4 itself rather than the remedial regime of 40915. Thus, pursuing that avenue would likely fail under Albright versus Oliver, a Supreme Court case, which held that where a particular amendment provides an explicit textual source of constitutional protection against a particular sort of government behavior, that amendment, not the more generalized notion of substantive due process for equal protection must be the guide for analyzing claims. Attempting to claim unequal treatment in comparison to the average American would likely lead a court right back to the Second Amendment. So basically, as I said before, in order to state a 14th Amendment claim, you need to have a Second Amendment right. And because they're going to jump back, because they're going to question the Second Amendment right based off of the 14th Amendment claim, then the 14th Amendment claim is irrelevant, because the only real issue is the Second Amendment. They're going to dismiss that, the 14th Amendment claim, on equal protection grounds, basically, if that makes any sense. So, and also because you fail to state a claim, also because you can't, like I said, you can't similarly name somebody that's in a similar situation as you, because nobody in the state that you live in, they don't have the right to get their rights back. So there's nobody being treated unequally, because everybody is being treated unequally, basically, in a way, pertaining to people that are barred from 922G4. And because it's constitutional, like I said, there's no discrimination by the fact that it is already constitutional, presumptively. So that means, again, a rough explanation, but regardless, the 14th Amendment claim would be waived under equal protections, basically. Let's see. So for the Second Amendment, in order to survive a Second Amendment claim, there's two things that you have to do in order to have a claim, basically. So, hold on, let me get another drink of water. So, in order to have a Second Amendment claim, you have to overcome two burdens regarding having standing within your claim itself. So first, so because your conduct falls out, because you are a class of people that are outside the Second Amendment guarantee, before reaching the purpose of the firearm, before reaching the guarantee, I keep messing up. First, you have to demonstrate that you are a law-abiding citizen who has the right to begin with, basically. But the Fourth Circuit, that's a court, federal court, has yet to address whether a felon dispositions are constitutional. By virtue of his status as being a convicted felon, the plaintiff does not have a Second Amendment right to bear arms. Basically, so obviously that's presumptively lawful because of your status, but you have to demonstrate that you're a law-abiding citizen, basically. Which I guess technically speaking you're not, because you are mentally ill by legal standards, basically. And then the second one would be okay. So you have to prove that you're outside, like if you're outside the bounds, that you have to that you're a law-abiding citizen. Again, I messed up a little bit, but for a Second Amendment claim, you have to. I said this earlier and I messed up, and I do apologize, but we'll try this again. There's two hurdles that you have to overcome in order to have a successful standing when it comes to the Second Amendment. You need to prove that you fall outside the historically barred people when it comes to the Second Amendment. So what I mean is that because it's presumptively lawful to bar people who are mentally ill or who are felons, you have to prove that you're somehow different than those people that are in that class, basically. And what I mean by that is that you have to demonstrate that your situation particularly is different. And that would be an as-applied Second Amendment claim. An as-applied challenge is a challenge where you're challenging the constitutionality of a law that is applied to you particularly. That's different than a facial challenge, which is basically you're saying that the statute altogether is unconstitutional. That's not what you want to do. You want to argue from an as-applied standard. As applied to you, this statute does not apply to you. Basically, for a challenge for an injunction, you need to basically need to prove that you're not like the historically barred people. And then the second way to overcome it too is the government has to prove that that you're that it's the government's burden of proof to prove that they that there's a historical aspect of like there's some law back in the day that exists that bars people that are mentally ill from possessing guns. Basically, they can prove that, then there's no case. Basically, I'm sorry, there is a case, but like those are analogs that they have to use to justify the prohibition in the first place. And again, it's jumbled up. So basically, if you can't get past step one, then they're not going to get to step two because you're not protected by the Second Amendment. So to prove that you're outside of that, you would have to get a job working for the government. Any type of governmental job would allow you to make yourself fall outside, exclude yourself from historically barred people in a way. And there's been successful cases that have argued for that, and that would be like cases like Keyes versus Lynch out of the Pennsylvania district in federal court. Basically, they did an as-applied challenge because they were state troopers and correctional officers in their state of Pennsylvania, and technically under federal law you're allowed to possess a firearm for work purposes. 18 USC 922A1, which is an exception to the disability, that if you work for any agency, department, or any type of governmental, basically any agency that's government, basically whether state, local, or federal, you can possess a firearm for work purposes. That's an exception to the disability. And basically, under that type of thing, if you work for the government, then you've shown that you've demonstrated yourself to be outside of the historically barred people because you've demonstrated a paper trail of your safeness of using a firearm, your ability to use a firearm without being a danger to yourself or other people. And that's the way to get your rights back when it comes to a defense for getting your rights back pertaining to saying that you're outside of the historically barred people, basically. Because if you don't do it that way, you don't have a defense because you can't prove to the government that you're outside, that you cannot distinguish yourself from the historically barred people, basically. It's impossible to prove that you are because there's no way to prove that you are because you cannot possess a gun, basically. So it's like saying, like I said in the other video, that so it's like the government making it illegal for you to have a driver's license, and it's illegal for you to drive a car, basically. And there's no way to prove that you're safe to have a driver's license or driving a car because the act of driving a car and the act of getting a license is illegal in the first place. And there's no way around that. And that but you could drive a commercial vehicle and work for a trucking company and get a CDL for work purposes, basically. That's kind of like how it is for the thing itself. Because when it comes to these cases, a lot of times when you petition the government to say that you're safe to have a firearm, a lot of times the only thing you're really relying on is your conduct after your commitment, and then a psychological evaluation from a doctor, basically. Because that's required for you to do these cases anyways. But basically your whole case is hinged off of one psych evaluation from a doctor, and psychological evaluations are very subjective at best, and a lot of times judges can deny your petition only because of that alone. You know what I'm saying? at least in state court. But federal courts probably wouldn't be any different, because judges have discretion to give you your rights back. So this would be like saying, like I said before, well, if you, you can get a physical, an eye exam, you could take the written test for your driver's license, but if you don't get in that car and drive that car, then all that's irrelevant. None of that fucking matters, because you can't drive the car. That's kind of how it is. Just like, you can get a psych evaluation and not gotten in trouble and not had any episodes mentally for your conduct to proving to a judge that you're safe to have a firearm. But at the end of the day, according to the federal government, none of that shit fucking matters, because you have no paper trail, no proof that you're safe to have a gun, because it's illegal for you to have a gun. That's kind of how it is. Like I said with the driver's license, it's irrelevant. If you can't drive the car, then all the rest of the shit doesn't fucking matter. None of the tests matter. None of the doctor's appointments matter. None of that fucking matters, because you can't drive the car. Just like with this. So, working for the government, police, military, any type of government that requires a firearm would help your case, because there is a proven track record of you having a firearm safely, and because you're entrusted within the state to execute the laws of the Union, you've demonstrated that you're outside the bounds of the Second Amendment. That is a defense. And they can't argue that, they can't dispute that, because it's a little record of you, by virtue of your job, the privilege of you working, that you're safe to have a gun. So you would have to work that to overcome the Second Amendment presumptively lawful prohibition for the mentally ill and felons. This would actually work for any of the 18 USC 922s, basically. There's 9 18 USC 922s, G's, basically. G1, G2, G3, G4, G5, G6, G7, G8, and G9. G1 is for felons, G2 is for fugitives, G3 is for drug addicts, G4 is for voluntarily committed people, which is somebody like me, G5 is illegal aliens, G6 is, people convicted in military court, G7 is if you're not your citizenship, G8 is if you have a restraining order, and G9 is for domestic violence convictions and the misdemeanor level, basically. So the only thing that 18 USC 925A1, which is the exception to the disability for the firearm usage for work purposes, the only thing that wouldn't cover is 18 USC 922 G9, which is convicted of a misdemeanor domestic violence conviction, basically. That's the only thing it doesn't cover. So even if you have that particular conviction, then you cannot possess a gun even for work, unfortunately. But regardless, for your case with the Second Amendment, for the as-applied challenge, you hold on, sneeze. Maybe not. Basically, that would be a great defense, and they can't really argue against that. But before you even file an injunction, you need to file in your state court to relieve the state right first. That's the first thing you have to do before you do anything else. I know I said file the injunction, but before that you file in state court. It's not going to relieve your federal rights in the 17 states that you live in, but once you get that done, then you file the injunction. But you would have to work a governmental job either before filing in state court or in between state and filing the injunction. Regardless, get a government job before you file an injunction, at least, for the Second Amendment claim. So I'm gonna read a little bit more on this on the site that I'm reading it off of. Again, it's a little bit convoluted, but there's cases, like I said, that have so if you don't do the government job, as I mentioned before, there's other cases like Beers versus Attorney General. That's another federal court in Pennsylvania, and Mao or something like that. Can't remember the exact names. There's multiple cases in federal court that rejected the the passage of time that has happened since your commitment to now, and then your rehabilitation from that disability. From the commitment itself. From the government's eyes, none of that matters because the passage of time, based off of what is it, Burn Up versus Attorney General, I think is the name. That's like a federal court case. There's no Supreme Court guidance on what qualifies or how long somebody can be committed for. There's no guidance on that because Congress's intent is to bar you for life. That's their intent. That's why it's written so ambiguously, basically. They rejected the plaintiff's claim that, oh well, this commitment happened over 20 years ago, or to the government it doesn't matter, because they live in a state that's non-compliant with the federal relief program. They're shit out of luck, basically. But with the Keys and Lynch cases, they're able to prove that they're outside of the historically barred people by virtue of their privilege of working as state troopers. So again, I'll say this again. You only can make a Second Amendment claim when it comes to the as-applied injunction. Fifth Amendment and the 14th Amendment doesn't matter because they're going to look at the Second Amendment as the basis of review, basically. Let's see what else. So basically, man, I keep messing up on this. Give me a second, I apologize. I'm trying to read this too. And I think I said this in the other video too. What you can do also, if I was you, I would use every loophole that exists within that exists in law, federally or state, to exercise your Second Amendment rights. If you absolutely believe in your right to bear arms, then you should use every loophole that exists. So what I mean by that is, so for example, under federal law, even if you're a prohibited person in all of the 18 USC 922 G's 1 through 9, you can possess a antique firearm, which is any firearm made before 1898, basically, or any replica thereof. Basically, what I mean by that is that, if it's older than 1898, then you can own it. But you have to keep in mind that you got to get a gun that's not convertible to use modern ammunition or what do you call it? It can't be converted into a modern gun, because if it is, then ATF can they have jurisdiction over that, and all the gun laws apply. If it doesn't, it has to be muzzle loader, black powder. As long as it's not convertible and it's made before 1898, you can own a gun federally, and there's no background check on it because it's outside federal jurisdiction, basically. But keep in mind, there's also state law too. Some states mirror what federal law says. Other states say it's prohibited for even somebody that's prohibited to have a gun to have an antique firearm. Like Pennsylvania, for example, they're one of those states that don't allow me to have a firearm, even if it's an antique, because I'm a prohibited person. Which is why, if you care about your rights, you got to exercise your rights in states that actually allow that. So, like Wyoming or South Dakota, Montana, West Virginia, Texas. There's other states too, but avoid states that are blue, like California, New York, Massachusetts, like all these states. Like I'm just saying, A lot of them have very strict gun control, like New Jersey, same thing. Um, Even if you live in those states, if you care about your rights, or you live in any state that doesn't allow you to have antique firearms, I would, as long as you possess a firearm in a different state, then they can't charge you for that, the state that you live in. So let's say you travel to West Virginia and you owned an antique firearm as like a felon or mentally ill. So as long as you're within the state lines of West Virginia, then you're not breaking any law because it's legal. Now, again, I'm going to preface this one more time. Also, there's also local laws too. Make sure your local ordinances don't ban it also. But generally speaking, if you live in a state that allows it, especially if it's presumptively lawful, like the use of the antique firearms. What I mean by that is that preemption, basically, that no local ordinance or municipality can make a law that bars the use of having antique firearms, basically. It just depends on the state that you live in. But generally speaking, you should be fine. So if I was you, I would exercise those types of firearms, and also, based off of the recent Rahimi versus United States case, the Supreme Court case that just dropped last month. Let's see. I wrote a quote from one of the justices, the main court opinion that was mentioned, and he said that Justice Robert, particularly, that the Second Amendment is not limited to only those arms that were in existence at the founding. Rather, it extends to all instruments that are not in existence at the founding. So not only does it apply to muskets and sabers, basically, which is a sword. So any arm that is bearable, any arm, whether it's a knife, sword, machete, crossbow, anything that's an arm, you could bear it technically under the Second Amendment, basically. Now I know the government might not recognize you having a Second Amendment right. However, if it's not illegal in federal or state law, wherever you're at, then presumptively I'd say it's legal, and that nobody can do anything to stop you from doing it. You know what I'm saying? I'd say it's constitutional. You're exercising the right that you should always have. You know what I'm saying? So, exercise every loophole that exists in law if you care about your rights in these 17 states to get your constitutional rights back federally. And as I said before, working government is a very, I don't know why, but they treat government as like it's like a special privilege to work for the government in a way. So when I said earlier, get a government job, you could also, even like if you're a felon particularly, you could run for sheriff. Now it depends on state law and where you live, but generally speaking, in some states, there's no real qualifications for sheriff other than like a high school diploma or you're a citizen of that state or some shit like that. If you're prohibited, well, now, for felons particularly, you lose certain rights because your conviction, like you lost a public office or whatever. But if you're not convicted of anything like the 18 USC 922 G4, the mentally ill, the involuntarily commitment aspect of it, then you didn't lose any civil rights other than your firearm. So you could go down that route too. If you, let's say you live in a state that doesn't allow it, then you could, wherever you live, or if you research other state laws, if you move there or something, you could run for public office basically in that state, whether local governments, run for sheriff, whatever you want to call it, especially sheriff, because the sheriff is the chief executive of the county, and the 18 USC 925 A1, the exception to the disability, would apply because you work for an agency or department thereof. Therefore, the firearms disability does not apply to you. So, see, there's loopholes around that you can get around. That's what I'm trying to say. So you got to work for government in order to have any defense pertaining to the Second Amendment. Because as a private citizen, you're fucking screwed. So yeah, I'm spreading awareness to get people to understand like what you're supposed to do when it comes to these types of things, because there's not that much guidance when it comes to these things, especially with the mentally ill type thing, because they just label you as mentally ill when one commitment like 15 years ago, that shouldn't determine, it shouldn't make you lose your rights forever. I don't believe in that. It's not something that I believe in. I never will believe in that. But the government does that, and it freaking sucks, So you got to do what you can to fight for your rights, because it takes away job opportunities and it takes away your ability to protect yourself and your family if you ever needed to. And I know I'm rambling and stuff, but this is just me talking about, my opinion about it. So I'm reading another one right here. Let's see. Yeah, so if you are a prohibited person, because I know I particularly talked about G4, the involuntary committed one, but any prohibited person, I guess except for G9, work for the government to get your rights back. Okay, let me try to articulate this better. So 18 USC 922 G1, G2, and G3, G1, G2, G6, which is the military court one, G8, and G9. Those are all technically convictions in a way. So in some sense, you lose your civil rights when it comes to running for public office or getting a job in the government per se. It's more like a criminal thing, kinda. So like, it'd be harder for you to get a governmental job for that aspect of it. But again, state laws are different, so different states have different requirements. But generally speaking, it's a little bit harder. But that's the criminal aspect of it, at least. How you can lose your rights. Then there's, G3. I mean, G3 can be criminal too, which is the drug addiction one. But generally, you can lose it from a drug test or whatever. But like G3, G4, and G5, which is G5 is the alien one, G4 is the involuntary committed one, G3 is the drug user one, G7 is if you renounce your citizenship. All those are civil in a way, where you lose your gun rights because something's civil. In those instances, there's no loss of public office rights or whatever for you to run for office, particularly the sheriff's department or whatever, or any mayor, anything. Like, none of those make you lose your rights. So, that's for running for office. And then all the G's pertaining to any type of knives, antique firearms, whatever, swords, machetes, crossbows, they're outside federal jurisdiction. So you go to a state that allows it, then you're able to carry it. So yeah, I'm just expressing my what do you call it? How I feel and how I interpret some of the laws or whatever. But yeah, you have to fight for your rights. Like, if you believe in your right to bear arms, and fight for it and use every loophole, like I said before. And from there, you strengthen your case, because you can't rely on the government to change your laws, the state or the federal. It's very unlikely that it can change because of the way that they are. It sucks, but that's just how it is sometimes. So you got to do these loopholes in order to strengthen your cases, basically. And eventually, some of these laws will be overturned, and more people that do it, basically, because But most people lack the knowledge and know what to do because there's no info out there to find out how you can get your rights back. You're going to pay for a lawyer, go up behind all these paywalls in order to get your rights back, or you might not even get it at all. It's really, really convoluted, and like that's just how the government is right now. So, you want to apply to every department out there, police department, sheriff's office, try to run for office, run for sheriff, commissioner of the county, if you want to go down the governmental aspect of it. Now, I mentioned the antique firearm stuff. It's not considered a firearm under federal law, so using that as a defense might not work solely if you only had that as defense, which is why again you got to work for the government plus have an antique firearm on top of your defense. You know what I'm saying? Like, oh yeah, to the judge. By the way, So Your Honor, I work as a police officer for this city. And you regularly carry a firearm because of 18 USC 92581, which allows me to have a firearm. So clearly I'm safe to have a firearm, and my police chief that is here today in court will testify, and he'll cross-examine, my worthiness and my credibility for having a firearm because there's a paper trail of me having a firearm. And on top of that, for at home, I carry an antique firearm. It's legal in the state that I live in, or the state that I visit, where I possess it. It's legal, and that's technically a firearm under the Second Amendment. And I have a knife, and I have a sword, all that stuff, because it's legal. And I had a psych evaluation from a doctor. They said I'm safe to have a firearm. All this evidence that I brought to court, the government doesn't have a defense, or they have no case on trying to say I'm not safe to have a firearm. Because, obviously the government's purpose is to ban anybody, keep firearms out of the mentally ill's hands. That is the purpose. But clearly I fall outside the scope of it because of my evidence that I'm safe to have a firearm. So, Your Honor, I think this is unconstitutional as applied to me, though it's constitutional to the statute is unconstitutional. I'm sorry, the statute is constitutional, 18 USC 922, all of them, as applied to me because of my unique circumstances. It's a suspension of logic to believe that I can have a gun for all these purposes, but it's illegal, and it's not right for me to have a gun for the private capacity of my well-being, to protect myself or my family. So, Your Honor, it's unconstitutional based off of these previous court hearings and court proceedings on how they lost, how they lost their right in the same way I did, and they regained it on there, basically. So from there, the court would be looking at the presumption. So you have to make them argue. You have to, and I'll reiterate this. You have to press them on the presumptively lawful aspect of it when you do an as-applied challenge. You have to. That is the only way they can look outside. Because if you don't do it that way, then they're gonna waive the. They're by questioning that lawfulness of it. There's no way the judge could ignore the evidence that you just presented, in your defense. So only on Second Amendment grounds can you win this case, because everything else will be waived. The Fifth Amendment and the 14th Amendment. The Fifth Amendment pertains to the federal government, and the 14th Amendment applies to the states. But there's no 14th Amendment claim because no state is discriminating against you because of a federal disability. So it's not the state's fault that the federal government is the one causing the disability, and the federal government isn't causing the disability because all you can demonstrate is that there's a mere possibility of discrimination, and since what I just read before, Congress allows the government to discriminate against immigrants, so because of that, it's okay to do that to you because of the presumptively lawful aspect of 18 USC 922 G4 and G1, which is felons and mentally ill. because it's already lawful. Therefore, you can already discriminate. So unless you attack that statue itself, then you have no case. So yeah, that's what you got to do when it comes to Second Amendment. And when you do those cases, you need cross-examination to show the evidence that you always need a witness no matter what, so they can testify in court on your behalf, and so that the defense could cross-examine that credible witness when it comes to testimony on your gun use for work purposes, basically. So these are for all the people that live in those 17 states: California, Colorado, Connecticut, Georgia, Maine, Michigan, Minnesota, Montana, New Hampshire, Ohio, Rhode Island, South Dakota, Vermont, Washington, Wyoming, Arkansas, and Mississippi. So yeah, it's one of those situations, and I reiterated a lot of what I said in the other video, but yeah, that's what you have to do, man, in order to get your rights back. If you care about them, then use every loophole possible to possess a firearm. Research your state law and federal law, but everything I said so far is correct. And yeah, file in your state court first, get a governmental job, then file an injunction in federal court. If you follow those steps, you'll get your rights back. Now, you need money, save up some money. If you have the money, it might cost you thousands of dollars, a couple thousand. It really depends on, obviously federal courts are way more expensive, so it's going to be a lot more expensive in federal court. So you need money, number one. You need to raise money to save your money, or whatever, get a better job, do what you have to do to do it, you know what I'm saying? That's what you have to do if you want to get a good lawyer in your state. And then from there, hopefully the more people that do it, the more awareness, the more cases that can be presented, and that causes more, that creates more case law, and more courts can use that to overturn these unconstitutional laws that apply in the books as it stands, federally and state-wise. Because like I said, you shouldn't lose your right forever because of a commitment or anything that you've done. You shouldn't. It shouldn't be forever, in my opinion. So, yes. That's my interpretation of it. This is my opinion. And if you have any questions or anything, feel free to message me in the comments or message me directly. And hopefully from there we can have a civil discussion about it, because I know this is convoluted, and I reiterated it over and over again, but hey, I was doing this off the fly, and this is just my interpretation of it and my understanding from talking to multiple people and reading stuff online about it. So yeah, I ramble, so that's just my fault, but yeah, this is me. So yeah, spread this message to everybody else, and hopefully we can have a conversation about this. So, alright, see ya.